Data can be collected through various methods, including biometrics, the internet, and direct marketing. Biometric data, such as fingerprints or facial recognition, can be used for security purposes, identifying individuals, and access control. How can this data be securely stored and protected from unauthorized access? How can individuals be assured that their personal data is being collected and used ethically when engaging with online platforms or direct marketing campaigns? In the following session, Ms. Pooja Shukla, Senior Lecturer at Hong Kong Metropolitan University, talks about the best practices in data protection for biometrics, the internet, and direct marketing. These practices include obtaining explicit consent before collecting personal data, using encryption and access controls for security, limiting the collection of data for specific purposes only, and having a clear policy for the retention and disposal of data.
Hello everyone, I hope you are doing well. We have got you another very interesting topic this time. As you know, I love telling stories. So I've got you another set of 3 interesting stories. Story number 1. Let us say it is a usual day of work for you, and you are in your office. And then you receive a call, and then you answer, and the other person says, "Hello, I'm calling from the police station. You are under arrest." You would say, "Oh, that's your old friend pranking you." You ignore the call, you finish at work, you go home. When you reach home, you notice that there are a lot of police vehicles waiting outside where you live. Now you are in trouble. As you get down there, you see the policemen come, handcuff you in front of your family, your children, and your neighbor. So humiliating, right? You keep asking them, "What did I do wrong? What did I do?" When you reach the police station, they tell you that you were caught shoplifting in a luxury store. They show you the photograph. But that's not you. You never even went to that store ever in your life. After a lot of investigations, of course, they let you go home. You are doing your normal day job. Of course, you have to take a lot of annual leaves to go and do the court work, the paperwork. Your co-workers are always suspicious what kind of person you have become. Later on, after all the investigations are done, the police comes in and says, "We apologize for our mistake, which was due to a wrongful, faulty face recognition system." Of course, everyone else goes back to their normal lives, except you. You lost that face. Okay, time for story number 2. Let us say there is one company, let's call it Company 1. So Company 1 is an American company which has introduced its virtual stores, which promises that customers could walk in, take whatever products they wanted off the shelf, and leave without checking out. If you read the company's FAQs, it says that items taken from the shelf will be added to your virtual cart, and when you put back the same item on the shelf, this item will be removed from your cart. Company 1 monitors your actions, and it charges your accounts when you leave the store. So convenient, right? It sounds like what we used to discuss when we were children, flying cars and virtual shopping. Similar type of technology this company introduced, it's called Just Walk Out. And to make this technology possible, Company 1 constantly collects and uses your biometric information, which includes scanning of the palms of the customers, identifying them, by applying computer vision, deep learning algorithms, and sensor fusion that measure the shape and size of each customer's body to identify customer and track where they move inside the stores and determine what they have purchased. So what is the problem? The problem is that this company one did not alert you as its customers that you were being monitored by this technology that was tracking your body shape, size, color, and your palm prints. Company one is accused of profiting from individuals' biometric data, something that violates privacy laws. Laws, as you know, require businesses to post clear signs if they are tracking the customer's biometric information, such as facial scans or fingerprints. Right now, this company is facing 14 class action suits and more than 75,000 individual cases of this kind of misuse or collection of biometric data. The executives of this company are facing legal action. The whole of this tech industry is watching very closely because this could dictate the future use of biometric data. Are you ready for story number 3? Let us say you are the head of your country and you are going to visit another nation which is not so friendly for some type of trade deal. And let's say it is still the time when you have to take coronavirus tests whenever you visit another place. Now that country asks you to give your samples because they want to test you for coronavirus. And that means you giving them your DNA. Now, I want you to think, during the pandemic, how many places did you go and what type of companies were taking your coronavirus tests or samples, or it was a requirement? Do you think all those companies where you submitted your data, your DNA, do you think they have not misused it? Just to tell you, your DNA could determine what type of things you could be allergic to, what is your race, what type of vaccine would work on you, and what type of vaccine could kill you. Sounds scary, right? So, I hope now you understand the importance of data, how important your data is, especially biometrics. So in today's seminar, we are going to focus on the best practices in data protection in terms of biometrics, internet, and direct marketing. Before we go further, I want to tell you, those 3 stories that I told you, what is the common denominator of these 3 stories? First, all of them are 100% true. And second, all of them entail some type of wrongful use or collection of any type of data, or not taking a proper required consent from the customers or people whose data was collected. Story number 1, where this person got arrested by some type of algorithm which failed to recognize him. You can read this story and you will understand how algorithms could not be trusted. Story number 2 relates to company Amazon. I'm sure you know about these stores of Amazon Go, where you can virtually shop, and all the information that you go and give as customers to the stores, the consent as such was never taken. And story number 3 is when, during the pandemic, when Francis Macron refused a COVID test when he met Putin, so Russia could not steal his DNA. This is quite interesting because when Macron realized that he had to take that test, which means his DNA would be passed on to another nation, if he had to refuse that, this would only mean that throughout this meeting, they had to sit at a 6-meter long table, as you can see it in the picture, which of course looks quite funny. There are various other stories that you can find all over the net which talk about wrongful use of data, wrongful collection of data, or not taking of consent while collecting the data. So let us discuss the first part in terms of the best practices relating to collection and use of biometric data. So first of all, what is the meaning of biometric data? So since we are discussing the Personal Data Protection Ordinance of Hong Kong, this biometric data is accounted as personal data under this ordinance. This data directly relates to an individual and includes the psychological data with which individuals are born with. It could also be some type of behavioral data. While it may not be reasonably practical for people like me and you to know whether this type of fingerprint relates to whom, but when you link those fingerprints with another person's data in another database, then you can identify that person. You might have seen that in the movies where they find some type of fingerprints at a crime scene and then they run it in their own database and they find that, oh, this relates to this person. So remember, even if these two are crucial and they become meaningful only when this information is combined. However, as per the law, this and these, both of them are personal data. So why do we need to be so cautious about handling this sensitive biometric data? The first reason is because it is sensitive data. It contains individuals' intimate information like health or mental condition, race, and it is often used to identify during criminal investigation because of how unique this data is. Any type of wrongful disclosure of your biometric data could lead to unintended or unauthorized or re-identification or identification of individuals, impersonation, or even discrimination. I'm sure you would have seen in those movies where serial killers are planning a new type of attack and they try to misguide the legal authorities, law enforcement authorities, by placing someone else's DNA at the crime scene so as to misguide them so that they are able to walk free from that whole situation. So this is why this type of data becomes extremely sensitive. Since the data is so unique, there's a high chance this would be misused. Let's see what are the pros and cons of this biometric data. Pros, of course, is a high security. I'm sure many of you are using your fingerprint scanner for using your banking apps or insurance apps. They require very high security, strong passwords, or strong biometrics. And the other thing is to enhance your user experience because now it is unique to you. Also, this is non-transferable. Sometimes you might accidentally share your password. When you were typing your password, maybe there was another camera behind you which captured your password. And now anyone can use your password. And this is where biometric data, since it is very unique, only you are the person in this whole world who has this particular fingerprint. So it becomes much more safe and it is non-transferable. Just like passwords could be shared, biometric data would not be easy to share. However, there are few cons like misuse of biometric data because it is very difficult for you to think or even anticipate where and how someone would be misusing your biometric data. The other thing is about privacy and security risks attached to it and false negatives like the story number 1 that I shared with you. Now let us see the 4-stage proportionality test which was developed in the case law of Hyson Development Company Limited versus Town Planning Board. So this test says whether the use of biometric data is proportionate measure to achieve the intended purpose. Data users may make reference to this type of test which was set out which determines the justification of a particular intrusion into fundamental rights, and consider, first, whether the measure pursues a legitimate aim, and whether the measure is rationally connected with advancing that aim, whether the measure is more than necessary for advancing that aim, or whether a reasonable balance has been struck between the societal benefits of the encroachment of rights and protected rights of the affected individuals, asking in a particular way whether pursuit of the societal interest in an unacceptably harsh burden on the individuals. Now let us see a few examples of what is known as lawful purpose. Collection of DNA by law enforcement agencies for investigation of a crime. It could also be facial images for immigration authorities for immigration control, and also fingerprints by employers for control of high security or restricted areas. So what do we do on or before collecting biometric data? The most important thing is you need to inform the data subject whether this type of provision of collection of data is voluntary or obligatory. If it is obligatory, what are the consequences of failing to provide this type of data? The purposes for which this data is to be collected and used. Who may access this data and under what circumstances? If it has to be transferred, what classes of persons it will be transferred to? Whether the data may be relied upon to take adverse actions against that individual, or if there is a right to request access to the correction of data, and if yes, to whom this request should be made. That means you need to inform this person at this post, this is the email ID or contact details of this person who is authorized to handle such requests. Next, let me ask you this way. Is your employer using fingerprint scanner for taking attendance? Tricky question. A lot of my students have told me yes. Now let us see if this is okay or not. First of all, the purpose or justification of collecting biometric data varies in different situations. For example, if your employer is taking your fingerprint data only to record attendance, or it could be to some type of security control. So let's say if you are an IT company and you have certain level of server which controls or stores all of your customers' data, or maybe if you are a bank, these servers are considered to be very high restricted areas. And if someone wants to go inside or change something, that person would need a very special access because this server contains all the confidential information. So let us see what is the problem if your employer is collecting your fingerprints just for the sake of taking attendance. Remember, the use of biometric data is not necessarily a better choice. Why? Because if you have certain type of procedures where your employer has to take your attendance, the most suitable idea for your employer is to give you access cards which could be protected by passwords, individual passwords. And in fact, most of the employers these days are using surveillance cameras to monitor restricted areas or computer terminals which regularly check what type of people are coming in or going out. So as much as possible, like I always teach you the concept of collecting only the data which is required. Any type of excessive data could land you or your employer into big trouble. There have to be continuous and indiscriminative use of biometric scanners, such as installation of fingerprint scanners. If you are using that to access areas like toilets, you must think twice, because these things will not be justified in case there is any type of leakage of data. The other important thing is when your employer is collecting that data, there are only two options. First, your employer is keeping your fingerprints data with the employer itself. Or second option could be your employer has some type of outsourced system where someone else, some other company which provides fingerprint scanning, they have installed that kind of apparatus, and all the information stored, all the fingerprints of your employees stored in that apparatus is going back, in terms of information, is going back to whom you have outsourced. In both the situations, this could get tricky, because first situation, if you keep it yourself, you will have to prove that you have taken utmost care in terms of securing that data. And second, when you transfer that data, do you have proper agreements with that company of sharing that data? And if the systems that the company to which this function is outsourced, can you rely 100% on them? And this is not even the primary point. The primary point is, why do you need fingerprints of your employees? You don't, unless you say that for this particular employee, let's say, is responsible to look after some type of vault that you have or some other type of locker, and only fingerprints is the best choice because in any other way this could be compromised. You have a valid reason, but you cannot apply this reason to monitor all of your employees. You cannot collect data, save data for all of your employees unless you have a very strong reason to do so. You might be surprised to see that in this case, one Australian guy won a landmark privacy case against his employer after he was fired for refusing to use a fingerprint scanner. So employers, if you are listening, pay attention. Now let us see what are the good practices in collecting and using biometric data. First, necessity and proportionality. You need to use data minimization techniques. Like I suggested, collect only the data which is bare minimum for you to function. The other could be privacy impact assessment, or transparency, explainability, and informed choice. Avoidance of covert data collection, proper audit and review. You need to make sure that there is proper decision making and human intervention. Retention of biometric data. You need to have proper policies, how long you are going to retain this data and in what form. Data accuracy, data security. You need to have written policies. You need to provide your staff appropriate training, whoever is dealing with this type of data. Lastly, the use of contractors, which are data processors, but make sure that the agreement that you have with the data processors is 100% solid in terms of it protecting you and you making sure that the liability of processing the data, or to begin with, transfer of data to these data processors is solid in terms of it protecting you. That is the agreement protecting you. And also, you could have some type of agreement in a written form with them where they advise you what type of data should be collected if you have any other advisor advising you on data. So my suggestion is make sure at least your paperwork is solid. So second part is about collection and use of personal data through the internet. I'm going to ask you a stupid question. Do you use internet? When I say internet, it could be in the form of computer, laptop, phone, iPad, or any type of device which uses internet. So many websites that we use these days require you to provide your personal data in order to access your services. So it could be contact information like your name, address, email IDs, phone number, or demographic information, which could be your age, gender, occupation, or your behavioral data like your browsing history, search queries, or locations. payment data like your credit card numbers or so, anything which uses to process your transactions, and social media data like your Facebook or Twitter profile information to make your experience personalized or for target advertising. How does PGPO apply to internet? Personal data collection using the internet, as you know, these days is a common practice, but there are concerns about privacy and data protection. There is a high potential for it to be shared or misused. There are various laws which are implemented and regulations which govern the use of personal data. And these laws require companies or organizations to obtain the consent before you collect the personal data and to make sure there is no unauthorized access, use, or disclosure. Now let us see what is the purpose and manner of collection. Like I always tell you that your personal data collection must be adequate and not excessive. Any type of excessive data will land you into big trouble. You should collect only the data which is necessary. For example, if no online order is there, then you should not collect residential address for any type of delivery. The other thing is about the purpose. You need to make sure that the purpose is properly communicated when you are trying to collect data. For example, you might have noticed some types of advertisements advertised for certain type of vacancies online, but in reality, they are non-existent. The other thing is the identity of organization. So you need to make sure that you explain properly what type of company or organization you are. A lot of the times on some websites you will see that when you click on their contact us, it only shows a box where you need to type in your query, and it does not explain where the company is located in or what type of email address or what type of people work there. So very often these types of companies or organizations do not disclose their actual identity. The other thing is about fair means of collection. If you are inviting submissions to fake lucky draw, that is not covered under the fair data collection practice. If you are using online forms on the websites, you need to make sure that you do not take any information which is not given under their consent. If you are asking them to submit their personal data, you give proper, clear information why you are collecting that data. The next is use of cookies and online behavioral tracking. If your website is using cookies, then you need to explicitly state what kind of information is stored in the cookies. If your website deploys third-party cookies, you need to explicitly state what type of cookies will be collected, to whom this may be transferred, and for what purposes. If your acceptance of the cookies is mandatory, you must clearly state that. If the acceptance of the cookies is voluntary, you need to state that too. And also you need to state if the user fails to supply this type of information, what will be the consequences of not accepting the cookies. And finally, when you are using online tracking, you need to make sure that you adopt fair and transparent practice. Now, let's see what are the recommended best practices on using cookies. Make sure you preset a reasonable expiry date for these cookies to make sure you are not retaining it beyond a reasonable period. Make sure you encrypt the content of these cookies wherever applicable, and not to deploy techniques such as flash or zombie or super cookies which ignore browsing settings on cookies unless your organization can offer an option on the website which allows them to disable or reject these cookies. The next is accuracy and duration of retention. So you need to make sure that the accuracy of the data is properly maintained. For example, you may use a double confirmation, a type of verification email when someone tries to register or log in to make sure that the person has input the correct email ID on your website. If online verification is not feasible, then offline verification may need to be performed. Now let's see what are the details in terms of display of personal data through the internet. Make sure personal data is not to be used for a new purpose unless you have received the prescribed consent. And disclosing or displaying personal data through the internet may constitute the use of personal data. So what can the organizations do? First, you need to make sure that you state at the time of collection that the personal data will be displayed. The second step is you need to anonymize the personal data when you are displaying it. And third, you need to limit the purpose of the use. Now let us start with part 3, which is personal data and direct marketing. How many times has it happened with you? Let's say you are on a vacation and someone has called you and you thought this was an important call from maybe one of your clients, and when you answer that, the other person is trying to sell you some type of beauty product. It ruins your mood. So let us discuss what are your rights when people are calling you without your consent. First of all, the definition of direct marketing in PGPO is defined as the offering or advertising of the availability of goods or facilities or services, or the solicitation of donations or contributions for charitable, cultural, philanthropic, recreational, political, or other purposes through direct marketing means. So basically, the meaning is sending information or goods addressed to specific persons by name, by email, by mail, by fax, or any other type of communication, or making telephone calls to specific persons. Now let us see what are the few examples of direct marketing. If you send a marketing SMS to your mobile number of a named individual, that is direct marketing. If a telecom service provider approaches you to upgrade the plan and you are its customer, it is a part of direct marketing. But if you send a postal mail and it is addressed to occupant, that means it does not have your name. There is no specific addressee on that. That is not covered under direct marketing. A marketing call to an unidentified owner of a particular telephone number, or a salesperson knocking on your door for a potential customer to promote his products. So what are the examples of direct marketing? Let's say in a furniture exhibition, an exhibitor collects the business cards from the procurement staff of a corporation and sends brochures to them using their mails, their emails, and their names or their addresses to market the furniture. In that case, Part 6A would not apply. If the exhibitor is not allowed to use the same personal data to market beauty products without complying with these requirements. So I hope this helps you understand the difference between what, in which case this Part 6A would apply and where it will not. For example, a bank collects your telephone number or addresses or any type of contact information for your savings bank account. The same bank cannot use the office telephone number and address to contact you to market a tax loan without complying with these requirements. The next concept is consent. I keep telling you that no matter what you want to do, just take the consent, and that makes you legally kind of safer than in the situation when you have not taken the consent. Consent is defined broadly to cover an indication of no objection. To qualify as an indication of no objection, you need to make sure that you have explicitly indicated or the person has not objected. You need to make sure that consent cannot be inferred from the data subject's non-response. So silence does not constitute consent. Do you remember that case in business law where one person says to the other, He writes a letter saying, I want to sell you my horse, and this is the price. If I do not hear back from you in the next 2 days, I will consider that you have purchased my horse. Do you remember that case? Anyway, so I hope that case and this case, this situation, in both the cases, the concept of silence not constituting towards consent or acceptance is built. Now let us see a few examples of what is constituted as valid consent. If you give an oral reply, okay, please send me the promotional offer. Or you say, I am interested to know more about the product. Please call me on this number at this time. Or if you do not check the tick box indicating objection to receiving the direct marketing material. Or you say, I do not object to the use of my personal data for direct marketing in an application form. All of these are examples of what is constituted under valid consent. Now let us see what is the meaning of invalid consent. If someone calls you and you immediately hang up, which shows you are not interested, that means the person is not giving you consent. If you call someone and the person says, I am busy, please call me later, I will think about it. That does not mean the person has given you the consent. Or if there is no response received from the person's side, or if a telemarketer ending a call upon queries from the data subject about the source of personal data used by the telemarketer. So what are the permitted class of marketing subjects? It means in relation to which a data subject has provided the consent to the use of or provision of another person or use of their personal data in direct marketing. So what are the examples of acceptable descriptions of classes of marketing? If you are doing promotional offers in relations to telecommunications network services operated by ABC company and beauty products offered by ABC company, what is considered to be unacceptable descriptions? If it says all goods and services of ABC company, which is a holding company of subsidiary companies with a diversified business portfolio, would be too vague without naming the classes of goods or facilities or any type of services. Goods and services provided by ABC company, related parties, agents or contractors or suppliers would be too broad. Retail services provided by ABC company would be too broad for the customers to comprehend what are the classes of goods or facilities. So make sure that the personal data is not collected in terms of being too excessive. You only collect data which is necessary, adequate, and lawful in purpose and directly related to its functions or activity. A few examples are: the name and contact information of a customer should suffice for the purpose of direct marketing. The data users should inform their customers that the supply of any of these personal data, like customer profiling or segmentation, is entirely voluntary, and make sure Hong Kong ID card is not normally required for direct marketing purposes. And it is not necessary for a bank to collect information about your education level or marital status for target advertisement in terms of their products. So the bank has to inform you that the provision of this type of data is entirely voluntary. So collection by means that are fair and lawful. It means lawful and fair in terms of every circumstances of cases. So data users should not use deceptive or misleading means to collect data. So what are the examples of deceptive or misleading means? If the actual purpose of making a cold call is just to obtain the personal data of a person, then it must be clearly, explicitly made known prior to the collection of the data. Let's say if you are company A and you try to pose as company B only to mislead the letter that you are collecting their personal data. So this kind of information is based on false reliance, And if the person discloses the personal data of that person, in that case, it will be considered to be deceptive or misleading means of collection. If you are offering gifts in the street to complete some types of survey questionnaires, whereas the actual purpose is to collect data. You might have noticed this a lot of the times when you are passing by Bangkok, and a lot of people making those makeshift stalls, and they are giving you some type of cookies, and they want you to fill that paper, in which, of course, you will have to mention your name, email ID, or maybe address, or some other type of preferences, or some type of survey, and you think that they are trying to give you free cookies. But remember what they are taking away in terms of that transaction. They are, of course, taking something very precious to you, which is your personal data. The other concept is of PICS, also known as Personal Information Collection Statement. So any type of statement given by the data user for the purpose of complying with the notification requirements under PDPO, and it is provided in writing to avoid any type of misunderstanding, and it is a statement as to whether it is obligatory or voluntary to supply the personal data, and PICS should be provided to every data subject by a data user on or before personal data collection. Some of the examples could be information collected from you would be used for this purpose, for your purchase orders or managing your account with us, or the information collected by means of cookies will be used only for compiling aggregate statistics on how visitors browse this website, or your name and address will be used by our leisure club for sending our newsletters and printed materials for recreational activities for promoting healthy lifestyle. So all of these things, when you read, you know where your data will be used if you give them your consent. I hope now you understand how crucial it is for any organization to make sure that the data, whether it is biometrics or internet or direct marketing, every organization needs to make sure that they are doing their best in terms of their policies and procedures. And the system of the organization is drafted in such a way that all these kind of hurdles will be overcome just because the way you have designed your system. So the next example is about Privacy Management Program, also known as PMP. This is the best practice guide drafted by the Office of Privacy Commissioner for Personal Data, in which the Privacy Commissioner has advocated that organizations should develop their own PMP, which helps to embrace personal data protection as a part of their corporate governance responsibilities and apply them as a business imperative throughout the organization, starting from the boardroom. It helps you to build the trust, enhance your reputation and competitiveness. It is also covered in the GDPR's accountability principle. GDPR is the European Union's version of PDPO that we have in Hong Kong. And the implementation of PMP becomes a global trend for organizations these days. So what are the benefits of PMP? So you can minimize the risk of incidents like data breach. You can manage your personal data more effectively, make sure that the compliance is properly done. It helps you to demonstrate your company's commitment towards good corporate governance practices and enhance the reputation and effective handling of privacy breaches to minimize damage which could arise from these breaches. So the first part is about organizational commitment. So an integral part, of course, is how you have drafted the systems of your organization. So governance structure or your board's vision to make sure that the data protection is properly followed within all those board policies, which need to stem, of course, at the grassroots level. It says the buy-in approach from the top, which means the top management starts that, and just like you water your plants, so just the same way your top management has to decide what will go down in the roots of your system. Appointment of data protection officer if required, or establishing any type of reporting mechanisms, So your board has to decide what type of PMP is good for your organization. If your company or your organization is of such nature where it is imperative for them to collect a lot of data, if you are a company which is a data processor, of course, it is imperative for you to make sure that your systems are so designed, and of course, you will have a proper data protection office, or you will need a data protection officer. So let us see what are the ways in which you could structure your data protection office. So you could have an officer under whom you could have several coordinators, and depending on the nature of your company or the size of your company, you could design this type of data protection office. The other thing is the structure of organization. So you could have a data protection officer who could report to maybe admin or IT, or collectively, or there could be a dotted line amongst all of them. So part 2 of PMP says program controls, which means any type of program controls which could be developed to be more compliant with the ordinance, and not just comply with the ordinance, but making sure that you are doing more than what is the basic minimal requirements at law, which means you always stay ahead of the legal requirements. Of course, as a good corporate citizen, it is your basic responsibility to make sure that you follow the law. But as a good corporate governance practice, you need to make sure that you always do more than what is required at law. So what type of program controls you can do? You can start from personal data inventory, your internal policies on how you handle data, risk management tools, training, handling, breach incidents, what type of communication you are doing. So if you are doing personal data inventory, you need to make sure you identify the personal data in the custody or control, what type of policies you have in terms of collection of data, accuracy, retention of the data, security, transparency, and you need to make sure you have proper risk assessment tools. Maybe you can also do some type of security breach drills, so you understand that, let's say in future, if you ever have any issue with a breach situation, so who will be doing what type of role in that communication or notification, or how you will handle that, or what type of board intervention will be required, or what type of reporting will be required at your internal level. So this is the sample of personal data inventory. So you can see in terms of departments, let's say there's administrative department and marketing department, and you can see what type of records you need to keep, what type of means of collection of data you have. So for example, if you are dealing with admin department, they would have employee information data. If you are dealing with the marketing department, of course, they might have, let's say, membership application data. And in terms of location of storage of data, if you are dealing with internal requirements, you could be storing them in your cabinets inside your records room. However, if you are dealing with marketing, of course, maybe you have both the options open to you. It could be physical plus electronic. And you need to make sure that all of these records are properly secured. So security-wise, you are solid. Part 3 is about the assessment and revision, which deals with all types of measures, policies, and procedures of the program, and how to make sure that these amendments are effective. The ongoing assessment and revision includes the development of oversight and review plan, and the assessment and revision of program controls. So when you are talking about oversight, you could say you need to develop a proper plan, and data protection officer or data protection office should develop this type of oversight plan. And the other access and revise programs controls, wherever you think they are required, make sure you revise your policies regularly, make sure you treat the risk assessment tools as evergreen, and properly provide training and education to your staff, and improve your communication internally as well as externally. So these are the samples of how you can draft your oversight and review plans. So you can see, let's say, starting from what type of month you would be doing personal data inventory, updating it, or conducting risk assessment. After 4 months, you will spend 3 months in assessing the effectiveness of your PMP program. After that, 3 months you would spend in reviewing and revising your PMP manual. And 1 month maybe you can spend in circulating the manual and making sure that all the guidelines are properly communicated to the employees who deal with this type of data. Or you could even make sure that these policies are updated, maybe on a shared folder, on the SharePoint or intranet, whatever your organization uses. And you could also spend 1 last month in executing this type of oversight and review plan. In the PMP review document, you could divide that into completed, not completed, when was it last reviewed, and what are the difficulties you observed in mitigating or the proposed mitigation measures that you have. And make sure you keep learning from your mistakes. And every PMP review document that you draft, when you compare that with the last one, it must show some type of improvement. If you are stuck in the same loop, again, it would show that you are probably moving in circles. And what are the other things that you need to improve? So make sure that there is proper communication between your employees, and also you do not shy away from taking legal help from law firms who are dealing with such type of policies or policy drafting, or other companies which are dealing with a lot of data, how they are dealing with these issues. To conclude, there are several issues that we still are facing. We are treating privacy as merely a compliance issue. We are doing the least possible to just comply with the legal requirements and we feel safe. We give little or no regard to customers' privacy expectations. How can we deal with these fundamental issues? First, your top management needs to adopt a proactive approach in its commitment to secure and save the privacy or the data protection. You need to inculcate the concept of customer centricity in your business equation and make sure that the system that you follow is following privacy by default or privacy by design. If you use all of this information and try to make policies around it, I can guarantee you that you would not just be following the law, you would also be adding value in terms of customer commitment, keeping your customers, your employees happy, and keeping your regulators happy and earning a good brand image for your company. So I hope you have learned the basics of biometric data, direct marketing, and internet. And you would be using that in your company, and make sure that your employer is making sure that all the data collected from you as employees is properly safeguarded against any type of breaches. I will bring you another interesting seminar next time. Thank you very much.